Good morning, viewer. Welcome to our first activity USA. Here is a breaking news from India. Sen Swami's demise should shake up the justice system on procedure and on judges' reading of laws. Stan Swami's death in judicial custody was an entirely avoidable tragedy, and pretty much very part of the criminal justice system is responsible. First, he was not even being tried. He was awaiting further proceedings in last year's NIA filed Elgar Parishat charge sheet. Second, NIA arrested Swami only a day before filing its charge sheet. This showed it did not need him for custodial interrogation. Therefore, investigative integrity would not have been threatened had Swami received bail. And this is the third grave injustice. NIA stoutly opposed bail pleas of an 84 years old with serious medical condition and one who has jailed when a pandemic was raging. Fourth, the trial court failed on courts of common sense, simply decency and judicial principles by stealing the bail of an octogenarian with the Parkinson's who could not possibly intimidate, witness or pose a flight risk. This terrible systematic failure is made worse by a more worrying trend, the freewheeling way serious charges like terrorism and being filed. Swami, accused of involvement in a Maoist conspiracy, had worked for some of India's most disadvantaged. His 2017 PIL, which came after painstaking research of SCSTs languishing for years of UAPA under 12 prisoners, as well as his long years of campaigning for Adivasi land and forest rights, are not exactly typical of a dangerous anti-national. Swami's is one of many cases where investigators' definition of what constitutes terrorism should attract severe judicial scrutiny. A strong case now exists for revisiting UAPA provisions defining terrorist acts and discouraging bail. Terror is currently too broadly defined in this draconian law, and UAPA's onerous bail conditions seem to tell most judges that severe dissection of the prosecution case is not warranted. There are a few exceptions to this judicial passivity. Assam activist Akhil Gogoi was discharged last week after a special court did not ever bother to send his UAPA case relating to anti-CA protest to trial. Delhi High Court recent bail order on 3 anti-CA activists also rubbished Delhi police UAPA charges. In February, SC grant bail to a UAPA accused incarcerated for over 5 years. Last month, Karnataka SC granted default bail to 115 accused in a Bangalore riots case. In these proceedings, NIA's plea for 90-day extension of probe had been accepted by a trial court without hearing defendants. But look at Elgar Parishat. Some accused are in prison for nearly 3 years. Courts have not framed charges to begin trial. Will Swami's tragic death give the system the shaking up its needs? From Posak TV, USA, we pray rest in peace of heaven, Swami Sahib. Beyond the report, Posak TV, USA.